Hey everybody, Adam Tracy here again. Hope you still retained your sight after yesterday's eclipse, and if not, you can at least listen to me. Today I wanted to talk about white papers. There's a lot of articles out there, what's the best way to put together a white paper? What do I need to include in a white paper? And as my answer is always, I don't really know. The big reason is because there's no particular law or statute that says XYZ needs to be in the white paper, but I think there's a couple of best practices in terms of what you should include, which will insulate you and do the best to provide your investors in an ICO with the best source of information regarding what they may be purchasing into. So my first bit of advice is do not use the word offering. Don't ICO, don't use it. Call it initial token sale, call it initial coin sale, call it garage coin sale. I don't care what it is. Don't use the word offering. Offering is a legal term of art. Okay, it has a specific meaning under the securities laws of this country. So if you're going to use offering, whether or not you are in fact doing a offering, you run the risk of describing your coin or token sale as a securities offering, and as I've said before, the objective should be to bring it outside the realm of the securities laws. So if you use the word offering, you're only giving somebody the impetus, whether now or down the road, to later come back either from a regulatory standpoint or from a civil standpoint in terms of a lawsuit and suggest that you in fact were selling securities when maybe you were in fact not. So if you're decidedly not going to sell a security in the form of a token or a coin, do not use the word offering. It is a killer. Do not use it. You don't need to use it. So ICO, initial coin offering, just get it out of the lexicon. Second, detailed technical analysis. Okay, and when I talk about detailed technical analysis, make it as banal as possible, right? Put every element in there, and with a particular focus on the utility of the coin and the proof of stake of the coin, right? Talk about less about the valuation of the coin or how the coin may value over time, because that's salesy and that's not necessarily the concept. Talk about the utility. Talk about, again, why this coin or token isn't designed or created to act like a security or act like a commodity. And the way you get around that, obviously, if you have something that is a utility token or it's a coin where you have a participation in a particular economy like Bitcoin, something to that effect. So detailed technical analysis, with which basically every white paper I've seen does, but with a special emphasis on the utility proof of stake elements, which define that coin or token and that sale of that coin or token as something not being a securities or commodities law. Third, big thing, disclose accurately the fees that you are going to earn as the promoter. Okay, if you are going to earn fees based on a commission, based on transaction fees, if you are going to earn fees based on X% per year, if use of proceeds with respect to the initial token sale or coin sale is going to go for website build out, employment fees, whatever the case may be, make sure those are detailed as well as possible. What you don't want to have, especially after the initial token sale, initial coin sale, is a situation where the promoters are getting paid and maybe the platform didn't take off as people otherwise believed, or maybe a secondary market didn't take off as somebody otherwise believed, and somebody gets upset, right? Somebody gets upset and goes, this guy took our money, this guy didn't disclose that he'd be earning X% per transaction, or whatever the case may be, and myself as a coin holder, an aggrieved coin holder, well, now I'm upset because I'm not sharing in the profit and I should be. So it's very important, much like you would in a securities prospectus, right? Which again, you're not doing. It's very important to detail what the promoter's earning, what the promoter is getting out of it, as well as the use of proceeds, right? If you're going to raise $1 million, what are you going to do with $1 million? If you're seeking to raise $1 million and you only raise $500,000, then what can you do with $500,000? And if there's a minimum, right, where if you have an all-in price of say $500,000 and anything less than that will not provide you with enough capital to launch the venture you're seeking to launch, you need to put that in there, right? That needs to be in there that says if we only raise $250,000, we'll have to continue to raise additional money or sell additional coins or tokens in order to meet that minimum. And finally, a big caveat. Now, the white paper to a large extent can be salesy. The white paper to a large extent is really sort of a high-level summary, an executive summary, if you will, of the coin, of the token, of the sale. What you need to do is incorporate by reference an underlying legal document, okay? And I tend to call them token sales circulars or something to that effect. Again, not using that offering language. You can use memorandum, you can use anything that doesn't suggest or have a legal implication that there's a securities element. So what I like to do is put together a underlying circular which is decidedly not salesy, okay? It's decidedly not salesy, and quite frankly, if you read it, it would look very much like a private placement memorandum, an offering memorandum, or a prospectus filed with the SEC. So it's risk disclosure, okay? And the common investor, in a sense, if they only relied on that risk disclosure, they would typically never buy your coin, right? They would never buy your share of stock if they just relied on a private placement memorandum alone. But that's the concept. The concept is to educate the prospective purchaser and provide them with enough information such that they can make a rational purchasing decision based on what they read. So when I have the white paper, I supplement that with a risk-based token sale circular, which details, incorporates obviously the details from the white paper, talks in length about particular risks associated both now and in the future with not only the individual token, the underlying business, but also like changes in legal and compliance aspects. And then talks about basic things like tax implications, risk of loss, things of that nature. And you can see those in many of the ICOs that I've done, and it's really just as simple to check the box prior to subscribing to the token sale, which suggests to the purchaser that I've read and understood the risks involved. And that is key because it, one, insulates you primarily against civil liability, because what you're basically saying to the purchaser, and that purchaser's representing to you, is that prior to participating in this token sale, I have read this document and I understand all the risks associated with my purchase here today. Whether they in fact read and understood that in detailed and can remember that, well, we all know from a practical standpoint it often doesn't happen, but it often doesn't happen at the highest levels of finance. You hope it would happen, but the reality is, from a legal standpoint, you need to link that document and the disclosures contained in there with that person's decision to buy. Therefore, if they were to come back at you in a civil context and say, I didn't get what I purchased, or I didn't get the benefit of my bargain in terms of like general contract law, you have that disclosure here that says you stated that you read and understood all these risks, and then you still went ahead and participated in the token sale. So that's a great defense if it ever comes to that. And quite frankly, living in the United States, anybody can sue anybody for anything at any time. So you're less reticent to say, I'm trying to avoid being sued versus I'm trying to avoid being found liable. And so that's the purpose of it. It's not a private placement memorandum in the context of like the equity world. It's not a prospectus in terms of the equity and debt world, but it's a hybrid of the same, which still provides the token purchaser with basic information that would educate them as to the efficacy of that token or coin sale. So those are my 4 tenets. It's a work in progress. I'm going to post here a little bit later some of the recent ICOs that I've done, where you can see some of these documents in motion. And then tomorrow I'm going to hit on the AML and KYC elements of a token sale and how it relates to disclosure and the same. So until then, Adam Tracy, visit me bitcoin-lawyer.org or tracyfirm, TRACY, firm.com, at tracyfirm.com. See you tomorrow. Thanks.